Hi, everybody. Welcome to Trial Alchemy. And I'm delighted today to have as my guest La'Verne Edney. She's from the great state of Mississippi, and La'Verne is the 2024 National President of the American Board of Trial Advocates, or ABOTA. But she's also a fellow of the International Academy of Trial Lawyers, the American College of Trial Lawyers, and the International Society of Barristers. La'Verne has received lots of recognition over the years of her practice. One example is Best Lawyers in America has been rating her as one of the best in the area of mass torts and class actions since 2016. So La'Verne has over 25 years of trying cases in very difficult venues in state and federal courts in the areas of mass tort, premises liability, medical negligence, and commercial litigation. And her trial practice over the past several years has been primarily focused on mass tort litigation involving pharmaceutical products and medical devices. La'Verne has been called upon to prepare and try cases in tough venues, places like Philadelphia, Pennsylvania, where in 2019 she obtained a defense verdict in a pelvic mesh trial. She's known for her ability to connect with jurors. That's an important ability, allowing her a unique opportunity to use her relatable life experience and calm resolve to explain complicated facts and evidence so that it's easy for jurors to understand. So without any further ado, La'Verne, welcome to Trial Alchemy. Thanks so much for being a guest today.
Thank you for having me. I'm excited to be here.
Well, La'Verne, I'd like to start off with my guests with a question of why don't you share with us one of your satisfying trial victories that you've had?
Wow. Well, you just mentioned one, and I think that is probably the one that I'm most proud of. I was a member of a three-person team of trial lawyers, a much larger team of trial support, but three-person trial team in a case in Philadelphia, Pennsylvania in 2019. As you know, Pennsylvania is a pretty tough venue. Um, we went in knowing that we had an uphill battle. It was a pelvic mesh case for a pretty large company that provides services and products for women who, have issues in the pelvic region. And so we knew it would be very difficult. But I'm most proud that we did get a defense verdict in that case.
Now, why is Philadelphia, with the kind of practice you have on the defense side, why is that a tough venue?
Well, it is because as a trial lawyer, we know that there are certain locations where um, the defense side is not very pleased, not always winning in those venues. I've had tough venues, even in the state of Mississippi, where I've tried cases. So when you go into a venue that is pretty plaintiff friendly. And what you do when you get those type situations is make sure that you spend the time with jurors. When you're choosing a jury, you make sure that you're spending time connecting with that jury, knowing that you can go into any venue and request that people just give you a fair shot, listen to the evidence. And once you start making that connection in front of those tough venues, I think jurors try to do the right thing.
Well, I certainly agree with you. I've had the fortunate experience of serving on two juries in San Diego,
Wow.
criminal cases. I was surprised in both cases, but both times I came away with the feeling that the jurors really, once they're selected, they're really trying to do the right thing. They may not analyze the issues the way we do as judges and lawyers, but they really do try to come up with the right answer. And I mean, the jury system works because they get it right most of the time.
And I totally agree with that. And one of the things that really makes me proud to serve as the president of ABOTA is that our organization is about preserving the Seventh Amendment right to a civil jury trial. We know that jurors are really important to the work that we do. As you know, ABOTA is equally divided between plaintiff and defense lawyers, and so what we do is we try cases. We have to have a minimum number of cases even to be a part of ABOTA. So we really get it, and we understand the importance of having that jury.
Well, I agree, and thank you for doing the hard work you're doing this year as the national president. And uh, let me ask for you, in addition, I know it's in large part because ABOTA is doing what it can to preserve and protect the right to the jury trial. But, why is ABOTA important to you? You've been involved for a number of years. You're now serving as its president. What makes it something really important to you in your heart?
Okay. When I first joined ABOTA and went to my very first meeting, I realized at that point that it was the right organization for me to spend my time because I really believe in the jury system.
Right.
I believe in judges making decisions independent of political stances, political positions. And I know that that is what ABOTA is about. And more so now than ever, I am just so excited to be a part of the work that we're doing in ABOTA because we need it now more than ever. Our judges are being attacked, our juries are being attacked. And we know that when jurors and judges give of their time to serve us in the capacity that they serve, we need to fight to protect that. We have a very unique system. Our United States system is very unique, and it's one that I don't ever want to see us lose. So, we're spending the time, the energy, our voices to really uplift the jury system and to come to the defense of judges when they are unfairly attacked.
Well, thanks for all you're doing and continue to do. And like you, I think we're very fortunate in our country to have the jury system and the rule of law that we do. So thanks for all your work in trying to preserve and protect that. Now, La'Verne, you try difficult cases. You're not going to come into a case if it's an easy case for the defense. You're going to come into a case with probably big damages, liability, causation issues, and lots of potential exposure. So over the years, you've gotten some terrific results, like your Philadelphia defense verdict. And most every ABOTA trial lawyer will start preparing a case in general from the beginning for trial, but everybody goes through the process of getting in the final prep mode. And I don't know whether for you that's a month or however long it is, but when you're in that final preparation mode, what kind of routine have you developed and what kinds of things do you do to get ready so you're ready to try that case?
Well, of course, the amount of time that it takes to really get ready in those final stages depends upon the amount of work that has to be done as far as reading depositions, reading medical records, summaries, those type things. I like to make sure that I spend some time with the paralegal, the other support team to make sure that I have all of the pieces of the puzzle. I call getting ready for a trial putting together a massive puzzle.
Hmm.
So I want all of the pieces. I want the depositions. I want to know what the hot documents are, some of which may not have been discussed in the depositions. I need to know what they are because I don't need to be surprised at trial. I want to make sure I know about the good documents. And then I get in what my friends would call a zone, where I kind of shut off from the rest of anything, and really get in my zone and focus in on d- putting this puzzle together, and coming up with how I want to go about presenting the case. Um, because at the very beginning, from the moment you stand in front of that jury, you pretty much need to know that your puzzle is together. And your job is to then present all of the pieces to the jury one by one. And at the end, they will have everything they need to come up with a verdict. And I hope it's in my favor.
Yeah, so you call it the zone. I kind of call it the grind, where we're sealing ourselves off from the world, right? And you're
Right.
just spending hours and hours going over documents and testimony and preparing exhibits for trial and things to use to impeach witnesses, all that work, right?
That's right. That's right. And I think it's really important for trial lawyers to really do that work themselves. It is great to read a deposition summary, but I tend to really want to read the deposition itself. I have different highlights, color coded stickies, all those type things that I need to really use myself to come up with my own summary. I often will type uh, certain responses to questions and the questions verbatim that I think will be very important for my case, along with the page number, the line number. So I have a cheat sheet for myself that I've created. I think all of those things are really, really important.
Boy, I agree with you. Even though it can be helpful if a paralegal or somebody prepares a summary, I think as a trial lawyer, you have to go through those depots yourself and you have to prepare your page and line summary and use that to prepare your cross-examination if that's what you're going to use it for. And I think you're absolutely right. You have to have the full question, full answer,
That's
right?
right. That's right. You're exactly right.
So I think that's really important. Now in the last year plus, we've been having the advent of this whole new thing called artificial intelligence or AI. Have you been using or have you used AI in any way in trying to help prepare for your trial? Have you found it to be helpful at this point?
You know, I am still at the stages of disbelief that it even exists. But we have started doing quite a bit of work in ABOTA to try to figure out how it can be utilized in a very fair way for clients and to make sure that it's acceptable in certain court settings. And so we've done some initial research. We have an AI committee that we started this year
That's
uh,
great.
that's looking at how AI will impact our legal system. We actually have a program where we will bring in all of the leaders of the different national organizations a day before our roundtable that we have twice a year with the national organizations, and that's going to be in September. So we know that change is coming. I have not gotten on that bandwagon just yet. I am just trying to learn as much as I possibly can about AI, but it has not been a tool that I've utilized in preparing for trial.
Yeah, I think we'll see some changes over the years, but we certainly don't want to be like that one lawyer who got mentioned in the media last year where he had all those sites and they were all made up.
Yes. Yeah, I think that taught all of us a lesson. I
Yeah.
have not been to any AI presentation where that has not been one of the topics of discussion. So
Yeah, from I know a lot of ABOTA lawyers, you know many more, but I don't think any ABOTA lawyer would have done that in any way.
I would hope not. I would hope none of us would do that.
Yeah. So Laverne, in your trials, you are defending a company or a product or whatever the issue is. And I'm sure there are some themes that you've used over the years that may have some similarity, but you may have changed things up depending upon the issues. What are some of the most successful themes that you've used in your jury trials?
I think it's really important to personalize the client, to talk about the client, talk about the good work that they do, the products that they provide, and products that work. And, you know, I think that's part of my trial prep. If I have not represented that client before, I want to know details about the kind of things that they've done
Mm,
um, in the history of their company. Um, because I think it's really important for jurors not to hear just what's in the confines or what's at issue in the particular documents, but to see the big picture. And so if I can explain that to to the jury. I think that's really important.
Okay, so that's very important, and I think you're right. It's very effective. Now, you see some really good plaintiffs lawyers on the other side. You have to go and try your cases against them. You probably heard some pretty good themes from them. You're trying to personalize your business owner or the CEO or the company. What do you hear on the other side that you have seen that you've said, that's a pretty good theme?
Wow, that's a pretty good theme. Um, you know, I think when the plaintiff side gets up there and immediately start talking about the bad things that the jury will hear, because the plaintiff gets the first chance to get up there and talk about it. When that happens, though, I like to be able to pivot and, address or at least let the jury know that they will hear more on those things. I don't want to run away from those things. They will hear why certain things are. So I think it's really important to be able to be flexible. But I have also had um, some plaintiffs' attorneys who use the same thing every single trial. If their
Hmm,
specialty is medical negligence or premises liability, they do the same um, thing over and over again. I don't think that that necessarily works. And here's why. In one particular case where plaintiff's attorney did that and he did it consistently, I already knew exactly what he was going to say. And so that allows me to really prepare and get ready to tell the jury why whatever he said was not so,
right.
um, and it just, to me, it gets a little old and boring. And so I try to be able to pivot and be flexible with things depending on the circumstances, the jury, the location of the trial, um, those type things. I think you have to be able to be flexible.
Yeah, I think that's true. And in terms of as a trial lawyer, and I've been on both the plaintiff side and the defense side, so I've done a lot of both. But I think if you can anticipate what your opponent is going to do, that's a very important thing because you can help prepare your case and you can strategically present your case to get the most bang for the buck, right?
You can. And there are definitely ways to do that to, you don't want to get too smart and fancy, but if you have, for instance, when I was talking about the plaintiff's attorney who did the same thing over and over again, when he did that, I had a whiteboard that I'd already prepared, that I just flipped the page over and showed the jury. I didn't write anything, it was sitting there during his opening, and I just flipped the page and it was a verbatim. It was
What the
verbatim
plaintiff's lawyer
what
was
the plaintiff
saying.
lawyer was saying. So things like that, to let them know that this is serious for me and my client who's been sued and spent millions of dollars getting ready for this. It's not a routine thing. It's not something, we want to get in front of jurors and repeat over and over again.
Yeah.
So, but
Well, another example of that, and you'll be able to hear this soon. I'm going to release this next podcast episode probably this week. And it's a interview I had with Eric Trout from Orange County, California. And what he has done, and one of the things he's explained is there's certain things that defense lawyers do very commonly in personal injury, auto, accident kinds of cases, and the way they go after the plaintiff and what they do. And he's taken that and he's turned it around on them. And it's just
Eric is a
great.
great attorney.
It's really good. So you might enjoy that. So Laverne, I love to ask everybody this question and I get different answers. And the only answer that's important is what you think. So got a lot of parts to a jury trial. What part of a jury trial do you think is most important and why?
I do believe that the very beginning from the voir dire is really the time that you get to connect with the jury, and you really get to talk to them and relate to them. So I think that's a really important part of the trial. But I also think that closing is another really important part of the trial. So I would say both of those are equally important because that's your opportunity to really, really connect in a way that you're not going to get to do it during the course of the trial.
Okay, so in the voir dire, you're connecting with the jury and you're telling them a little bit about the case and what they're going to hear.
Mhm.
And we'll talk more about that. And the final argument, you're now able to you gave them an overview and told them the story in your opening statement, but now you're really bringing it all home, right?
You're in addition to bringing it all home, you are getting them to know why you spent time talking to them at the beginning.
Yeah.
You're getting them to understand their importance at that point. You've said it at the very beginning, but at the end, I think that's a time to drive home their important role
Oh,
in resolving the matter.
now a lot of people in the research will tell you that a lot of people will make up their minds early on in getting information. So that's why a lot of folks will say, voir dire or opening statement are so important. But it sounds like you've also had experience in your arguments, in your final arguments, where you think that also made a difference. So you think that can make a difference and you can change some minds or kind of get enough people to get the votes you need to win the case, and you've seen that happen?
Yeah, I think so. You know, jurors tend to kind of fade off a little bit after the middle of the trial. I think there may be truth in that they've already made up their mind. But I think it's so important and so key to, at the end, be able to pull together all the pieces of the puzzle to them that they've heard and re-emphasize it because they may have tended to fade off a little bit and may have missed a piece that goes here. I think that just gives you an opportunity to kind of pull it all together and really answer any questions that you have seen based upon your observation of the jury. Because you can look at a jury and see when certain things didn't quite connect.
Yeah.
That's your chance to kind of connect the dots with what the evidence has shown.
Now, I don't know if you do this in your trials, but the way I've tried cases when I was trying them is I was a little more objective, reserved early in the trial, trying to build credibility and all that. But it does seem to me, whether on the plaintiff or defense side, when you get to the final argument and you're putting the whole thing together, you can now show some passion and all that. Do you do that in that closing argument that you make?
I do. I do. And it certainly depends on the kind of case that you are trying. But I've done quite a few cases involving the loss of loved ones in nursing homes, that kind of situation where um, there's a lot of compassion. And I think it's really important for the jury to understand that you have that same human compassion. However, the case is about whether or not your client is responsible for this condition or this death. Um, and so that's your time to really work on even further that connection that you made early on with the jury in explaining what the law requires the jury to do. Um, and it is to put aside the sympathy, but it just gives you an opportunity to personalize your client um, and talk about the fact that although we feel compassion, we have to follow the law.
Yeah. Okay. Well, that's great. And you will share that I mean, what might be an example of how you share your compassion for what the plaintiffs have suffered. Can you give any example of that? How you might show, hey, I understand.
Yeah, I can, I guess from a standpoint of some of the litigation I've done where patients have ended up with, let's say, a terrible bed sore that led to um, eventually the demise of a person. I think those are horrible cases to try. And I've tried some cases that are not very pleasant, but I think you have to embrace uh, the bad stuff, even to the point of in voir dire, if you can get away with it, showing the picture of the wound yourself
Mm,
and telling people if you cannot stand to look at this, and you feel like somebody is responsible for this right now, and it's my client because that's where this patient was at the time that they developed this or it progressed, then you probably don't need to be on this jury. If you cannot be fair and listen to the evidence and make a determination after all of the evidence, and occasionally you'll get someone that says somebody had to have done something wrong, period, at that location. And I think at the end of the trial, you have to do that again. You have to remind the jury that they made a commitment to listen to all of the evidence, to make sure that they are listening to the jury instructions and making a determination, not based on the sympathy. And, you have to agree, yes, this picture, the very first time I saw it, I had to just turn away. So they need to understand that you are not cold and stoic. You are a person, it's human, but we've got to follow the law.
okay, that's great. So when you're getting ready for trial, La'Verne, do you use tools like focus groups? And if you do, how do you find them to be most helpful?
We have definitely used focus groups, and I think it's the most helpful thing about focus groups to me. They allow you to test themes, and you know, I know a lot of times we will pair certain demographics of people in certain jury rooms for them, to see which type juror we want on a trial, which I think can be effective. But I don't necessarily walk into a trial and look at the jury pool and decide I don't need older people or younger people or black people or white people on this jury. I think we all can connect. I look for connections
Mm,
and not necessarily demographics. I think where focus groups really benefit us is just the testing of the themes and seeing what works and what does not work for people. Um, so that's the most benefit I get out of it. Not the determining whether or not we need to X out people before we get an opportunity to talk to them.
And I'm sure you, like all other lawyers, have used focus groups. Sometimes the focus group will have a reaction to something that's very different from what you thought it might be, right?
Absolutely.
And you learn because sometimes we're so close to it, we can't see it the way the jury's going to see it because they're just new to this whole thing.
That's exactly right. And I think it's really helpful to know that up front because we live with this. We live with these cases. We've gone over materials, so we know it when we walk in that courtroom. But it's interesting to hear the little things that are important to the jury,
Yeah.
the things that they really want to hear. I wonder why they didn't get anybody to talk about X when, we may have totally missed that. So it's really helpful to hear their thoughts.
Yeah. Well, Laverne, in the last, I guess last 10 years or so in California, we've had the development of what we call mini openings, and I think those are also being used throughout the country. Are you dealing with those in your jurisdictions where you're trying cases?
Yeah, we've been doing it for a while. There are some judges who prefer just giving a general statement about what the case is about. And then they will allow you maybe an additional 5 or so minutes to say anything that they have not covered. Then there are other judges who don't say very much other than who the parties are, and they allow you to get up and do your mini openings. Um, I try to keep that as brief as possible,
Mhm.
uh, knowing that you'll get a chance again to do, a full opening. Um, and the way you really take advantage of these mini openings, if the judge is open enough to allow you to do that, they're enough to allow you to um, s- specify your questions, where you're really doing a mini opening within your questions. Um, if you understand what I'm saying, you can really intertwine some of the facts um, specifically in your questions to really get the best jurors.
Yeah, and so you like them and you have found them to be helpful in defending your clients?
I have, I have.
Yeah, I've talked with some other folks who are defense lawyers, and some of them have said, "I didn't like him at first, but now I love him."
Right, and I think it just depends on the judge. The judge, if they have a good grasp of the courtroom and don't allow it to get too out of hand, I think it works well.
Well, Laverne, when plaintiffs' lawyers in your cases are bringing cases where they're going to have big damages and they're probably going to be wanting to talk about that, and there's some different points of view on the plaintiff side of the aisle about, how you bring up the dollars and when you bring up the dollars and all that. Have you ever seen any examples where, however it was done, it didn't work very well on the plaintiff side? Because I think one of the dangers for that side is it might backfire depending upon how they present it or what they do. So have you experienced that ever?
Yeah, yeah, I have. I think it is very dangerous to really, you know, ask for huge numbers and talk about the net worth of a company early on, because I think once the jury starts really listening to the fact that your particular product is this much of the amount that you put before them in opening, it begins to look like you've inflamed the numbers. And I think that there's so much we can work with as defense lawyers when that happens, because you've got to consider not only the product, how much of the income is that product. You've got to think about the state, how many people in that state
Yep.
even purchased that product. So that number that appears to be so huge, during the course of the trial, you can definitely dwindle that down, and it kind of makes the other side look bad when you start doing that.
Well, now when you're doing your voir dire and you're going through the process of talking to the juror and trying to make a connection with them, when you're deciding on who you'd like to try to keep on your jury, are you using jury consultants in your trials with these big stakes? Do you do that all the time? And how do you work with the jury consultant when you're using them?
Sometimes we do, and sometimes we don't. For the larger cases, of course, the clients tend to like to have jury consultants, and they can be very helpful. I still think it is up to the attorneys who will be trying the case to have a great deal of input into how they feel about people who are seated on that jury, because ultimately it is that connection that's important. I do think for jury consultants who do the homework, looking at certain posts and things like that, that may be valuable, to kind of look inside of the jurors, outside of the questions that you ask in voir dire. That's really helpful. But when you're sitting there and making that connection, I think it's ultimately the trial lawyers and how they feel about those potential jurors that really, really is important.
Yeah, you're there on the front line.
Yeah, that's right.
Dealing with them. So now let me ask you this. This may be most helpful for somebody who hasn't tried their first case yet, but you've talked about trying to make a connection with your potential jurors. So how do you know when you have made a connection? What kinds of things do you observe or hear or feel that gives you that, aha, I've got a connection?
That's a big question, and I think there are a lot of different answers. You know when you get head nods, when people are comfortable enough to really answer the questions, when they seem to be anxious to suggest that maybe if you I, now are you asking, I want a conversation. If people are, into the questions enough to talk back to me, I know I'm making that connection.
Ah.
Some jurors have tried to reframe my question so that they can answer. Um, so you kind of tend to know, and then you have those jurors who sit there and will not say anything at all. And if you can make a connection if they start talking. If they don't start talking and they're still kind of, no matter what you say, I don't want to be bothered. Um, you have not made that connection with them, and
Yeah, that makes sense.
you kind of watch them and you see if they talk more to the other side, if there's something wrong there, you try to figure that out so they don't end up on your jury.
Mm. Now, as time is going on and everybody is aging, we're seeing the baby boomers getting older and getting into retirement and all that kind of stuff. And we're seeing some of the younger generations starting to probably come in and be in the jury box. Are you noticing anything in your trials in the last 5, 10 years where you think, hey, there's some differences that I'm detecting in younger generations, or do you feel it's a similar kind of make a connection with an individual?
I think, so far for me, it's been similar. It hasn't been a big change. I think for younger people, you have to figure out a way to keep them connected, more so than the older generation. We used to think, excuse me, we used to think that the best thing for us to do was to take a whiteboard or, a white chart and set it up and use the highlighters and all that stuff. And a lot of trial lawyers still want to do that. But I think if you look at your jury and they are of the younger generation, they're going to be more fascinated and you will have their attention longer if you put some color on the screen and
Yeah.
yeah.
That is very true. Well, in terms of picking a jury, do you in your different jurisdictions ever ask for jury questionnaires? And have you found them to be helpful? And how receptive or resistant are judges to using them?
I found them to be useful. And in Philadelphia, we used them. And I thought they were really helpful because we found out some things that we needed to know early on. The process went a lot smoother because you already have some answers, so you can just ask questions based on those questionnaires.
Yeah,
I found them to be very helpful. You have some judges who are resistant to using them, especially locally here. But I think more and more people are realizing the importance of them, especially when you have a trial that's going to take a while.
right. You know, the irony that I came to, I've used some questionnaires and trials, and my conclusion is when we're picking the jury and the judge is asking questions and we don't have a questionnaire, the jurors are most honest in answering the judge's question and least honest in maybe answering our questions. But if you have a questionnaire, they're even more honest in answering the questionnaire questions.
That's true.
And kind of the judge is the second most honest.
Mhm.
So I think you really get some good insights. And I know judges may be afraid about it taking time, but you may make up time
I agree.
a lot of the times you have them because you're really getting such useful information. It helps
That's
you
right.
get your job done faster.
And people are really more comfortable when they are sitting in their own privacy
Yep.
and writing responses to those questions. They're
Yeah.
not.
Yeah. I think we forget how uncomfortable the courtroom is because
Yes,
we're living in that world, but they're not.
that's so right. And I try to keep that in mind when they walk in. They've been in a holding area for probably a couple of hours. They've
Yep.
been filling out paperwork. They've been hauled around, and then they walk in, and we're sitting there staring at them, and the judges. It's just the whole process.
Yeah. It's not often you walk in a room and everybody's staring at you.
That's right.
But that's what we do with our jurors for sure. So Laverne, in your opening statements, do you like to do things where you're using graphics and pictures and other things, or maybe video clips? How do you like to tell your story, and how do you like to present it?
I love to use PowerPoints. I try not to use them, too much. I want the jury to look at me. So I have blackout periods on the screen where they
Mhm.
it's on me. But I think it's really important to show them if there are really important nuggets that you really want them to hone in on during the course of the trial. I think it's important to show them that. I think one of the benefits, as boring as it is, when the other side decides that they want to play video of witnesses, then you know exactly what's going to be played.
Yep.
Um, I think it's important if you have something that you want the jury to focus in on, tell them when you listen to this video, you're going to hear this, put it verbatim. And then when it gets to that witness, they're going to be looking for what you said. That's what's going to be in the forefront. I just can't wait till they get to the part where she said they're going to say X.
Hmm.
And I think that's really important. Then, as far as um, the documents that you have pulled out that you think are key documents, um, I like to warn them that you will see these documents over and over again, and the expert or the witness will explain exactly what it is. But I want you to look at this. If it's a date, if it's a diagnosis, if it's something, highlight that so that that will be on their mind when that document is brought up. Little things like that. But I think it is key to have some visuals, especially if you have, like I said, a younger jury pool.
Yeah, I think any way that you can use multiple senses, you're going to help them remember it and kind of get it cemented it into their mind better.
Right.
So that's helpful. So now, when you go to trial, you're not going to go to trial if you've only got great facts on your side.
That's right.
Neither is the plaintiff, probably. So the question is, as a defense lawyer with the kinds of cases you're defending, how do you deal with bad facts? And how do you deal with, in your cases, sympathetic plaintiffs who come across as nice, likable people?
Like I mentioned earlier when I was describing the case involving a nursing home patient, those are tough cases. Cases involving children who are injured, cases involving women who are injured, and in the
Hmm.
pelvic mesh world, that those cases can be very sympathetic because they involve a lot of things as it relates to a woman's body. I think you embrace the bad thing. You talk about it. You talk
Mm.
about it early on. You don't shy away from it. You've got to talk about it. But you've got to make sure that the jury understands that they're going to hear a lot of things, but the ultimate thing that you're going to hear at the end of this trial will be the jury instructions from the judge. And that's what's going to matter, whether or not this company is responsible for these horrible things that you're going to hear throughout the trial. No one's saying they're not bad. The thing is, you got to make that connection and make sure that it's my client's fault. And so I think throughout the trial, you're not beating up on anyone. You're not acting like they're not hurt. But what you want to get across to the jury is the fact that it's not your client's responsibility.
Right. Okay, well, that's great. So now we're in the presentation of the trial, and plaintiff gets to go first. And let's talk a little bit about cross-examination. Direct exam may be underrated, but that can be very important. Do you think, isn't it pretty important in your cases how your main witness comes across for the company in direct and cross?
Absolutely. The main witness a lot of times will be the expert. And I think that giving the jury a connection early on to that expert is important. Introduce them in the opening statement that they're
Yeah.
going to hear from that witness. Tell a little bit about that expert. And then when the expert is on the stand, allow them to be a teacher. The jury is looking to get um, the most information from the expert because they are designated as such by the judge. And so a lot of times I will have the expert come from the stand if the judge allows that and kind of talk to the jury, especially when it deals with medical issues. And really educate the jury. You don't have a little time to do it. Talk to them where they really understand. For instance, in the nursing home litigation world, where you got the wounds, you talk about skin being flesh. It is flesh and it's an organ.
Yep.
Um, and as organs inside your body shut down, then organs that exhibit themselves through your skin, they're shutting down as well. Your skin is an organ. And for her to, explain that or anything dealing with a medical negligence case, I think it means a lot when the expert, your main witness, is connecting to the jury.
Yeah, and in terms of the experts connecting to the jury, um, I imagine you probably like to have experts who can explain things in a simple way and not use a lot of their jargon from their own profession, because we all have that.
Yes, yes. And I think the way you do it to make sure that you're not demeaning the jury is for you as the attorney to offer the, you know, question in a way where the jury understands she's not dumbing us down. She's actually trying to understand. For instance, if I've got an expert up there and he or she has just used a medical term that I don't understand, it's my job to say, now, you just use, I can't even pronounce the word, Miss Doctor, whoever. Can you explain what that means to me? Because I really, I need you to break it down. And that way, you're putting it on you, and it's not, you're not making the jury feel bad about it.
Yeah, and so that's a way in your direct exam of your expert, you can help explain things that are more complicated, simplify it,
That's
and
right.
make sure the jury gets it, even though there may be medical terms that have to be used, right?
Right. That's right.
Well, now let's talk a little bit about cross-exam, which can be pretty important cases too, because if you're effective in your cross-exam of either the plaintiff or one of their experts or other things, that can make a big difference in a case. So lawyers are kind of taught, everybody in law school is taught what I called the closed cross, where you're controlling the witness, short questions, not letting them say much, trying to get a yes or no. But there's some totally different kinds of cross performed by people in the past, like Jerry Spence and other plaintiffs' lawyers, where it's not controlling, they're just all over the map. Do
Yeah.
you tend to use one or a different type, or do you use different types of cross depending upon the witness and what you're trying to do or accomplish? How do you do it?
It totally depends upon the witness. And, there are some witnesses who talk so much that you already know the jury has not connected with them. You don't need to spend a lot of time. You can just, in your closing, you can just talk about, did you hear? I mean, you sat through 2 days, and let's see, in essence, here's what he said in one sentence. And so I didn't ask a lot of questions because we were not going to get a straight answer from this expert, and just move on. But then there are others you have to get them to admit certain things, or try at least, and some will fight you tooth and nail. And you just have to know how to put the questions out there. If they don't answer them, you have to know how to let the jury know that they didn't answer the question, and just leave it there.
Okay.
Yeah,
And
I
when
tend to
you're,
do a mix. It just depends on the person.
well, in the federal jurisdiction in California, I'm sure in your state and all the states you practice in, the plaintiffs typically have an opportunity to put a defendant on the stand under cross in the plaintiff's case. In California, that's evidence code 776. But have you ever seen that? I mean, one of the downsides, as I see it, is the plaintiff gets their best shot, but then you get to tell your story right afterwards. So
Yeah,
how does that work for you? Do you like that opportunity?
I love it.
You,
I love it, because, strategically, I think it just works better when you're able to get them to, after they've been beaten up, you get up there and say, I just want to give you a chance to let this jury know who you are and what you do, and just, bring it all back home. They tend to remember what they've heard, that that's not so combative. And so,
well, now over your years of practice, have you seen any changes in how often the plaintiffs use that opportunity to cross-examine the defense in their case in chief?
I've seen them kind of understanding that that may not be the best strategy.
That's that's what I grew to believe, because I used to use 776 on plaintiffs cases more earlier, and then I started to go, I don't think I like this.
Yeah, yeah,
If I'm on the defense side, I was happy
right,
like you.
right.
Hey, well, when you're doing your cross and you're impeaching the witness because now they've said something different than their depo, and you got different ways you can impeach them. But what's your favorite way that you think is really the most effective in impeaching witness? What do you like to do?
Yeah, so I like to, you've got to know that transcript. You've
Yeah,
got to do the
yeah,
question almost verbatim. And the way I like to do it is ask that question verbatim.
yeah.
And, if they've said something differently, you just turn to that page and say, you remember when this question, you know, quote, and your response was different. Your response at that time, can you read it for the jury and let them read it? I think that's the most effective way to do it. And then in closing, you can show the jury again if it's a very important point. You can, just read that little piece where he changed that answer. Um, but I think, those things can be really, really effective, and those are things that the jury will remember.
So you like to have the witness read the transcript. So you ask the question that you asked, and you have to do that. You have to ask the same question,
Mhm.
but they give their answer. Now you force them to read the earlier answer that was different.
And if they are not cooperative in doing that, I will say, okay, well, let me read it verbatim.
Yep.
So I'll, do the question again, and this was your answer. Do you agree with me on that?
Right.
It's on page, whatever lines. Do you agree that that's what your answer was? And remind the jury that it was given under oath.
Now I'm sure you've had this happen, because I think anybody who's tried cases, a number of cases, had this happen. So you have a witness like this, you're hitting them on cross with they're telling you something different. You ask them another question, you hit them again, have them read it back. have another question. They're trying to play with you. You hit them again. After a while, what
After a
starts
while,
happening?
after a while, you just reach over and get the transcript, and
And
then,
they agree
then you
with
want to
whatever you
answer.
say.
Right, you have a little fun with it at that point.
Yeah, that's so funny. Something else that's kind of similar, but when you do your direct exam and then the opponent does the cross, when you do your redirect, you're not supposed to ask leading questions, but I found I can ask leading questions all I want because they've forgotten about that by now. Oh, so
Yes,
it's fun what you can do in the trial
it
and all
is.
that. So, when you're getting down to your closing argument and you're putting that final thing, and that's an important thing. We talked a little bit about this. Um, this is really a key time. So you're trying to make that final connection with them. And anything else you want to share with us about closing arguments that we haven't talked about? Because I think we've talked about it pretty well, but anything else?
No, I think that's it. You want to make sure you're organized and that you're not shuffling, and that you have really paid attention to the trial and you're not reading or closing that you wrote before that last witness took the stand. Um, so those are key things, and also that you're able to address some of the things that have been said by the plaintiff side, and remind the jury that this is your last opportunity to stand before them. Um, so
Okay. So when the jury comes back in and after the verdict is read and you've done any polling you're going to do and all that, do you commonly go and try to talk to the jurors if they're willing to talk to you? And what are you trying to learn and what useful information do you get?
yeah, I'm really interested in talking to the jury, especially if I have a number of those same type cases. Um,
Yeah.
I think the information they provide is invaluable. What works, what does not work, whether or not they like the expert, what things they wanted to hear that the expert may not have talked about that they think would have been helpful, what they didn't like, um, what they thought was most effective when it comes to the arguments. Do you think the witnesses stayed on the stand too long? What do you think about video depositions? All of those things. If they will take the time to answer, um, I will ask questions. So, and I've had really, really good feedback from jurors. Sometimes it's not everything you want to hear. It may be, um, well, for instance, one juror didn't like the color of the suit that my co-counsel had on. So they watch everything.
Oh, yeah.
Yeah, they're looking at
They
everything.
watch everything. I mean, I can tell you, having sat on those two juries, nobody's going to see everything, but between 12 people, somebody sees
Yeah,
everything.
that's right.
They
That's right.
see everything and they hear everything.
They do. They
They
do.
really do. Well, this has been a wonderful discussion, and I really think it's going to be useful and helpful for anybody who listens to the podcast. And I appreciate so much your willingness to take the time. So, La'Verne, I want to finish up in our conversation today with what advice would you give somebody, either who's a young lawyer who hasn't tried any cases or maybe tried a few but wants to try cases? What advice, whether you got it as a young lawyer yourself or you've learned it throughout your career, what would you tell them? How can they try to become really a capable trial lawyer?
When given the opportunity, take it. Don't let your fear overcome you. We all have gone through the fearful part of standing up in front of 12 people and risking your client's company. That's how you feel. You feel like, it's all on your shoulders, and anything that happens in that trial is your fault. The best thing I can tell a young attorney is to go in there, give it a try. Gotta go in prepared. Do what it takes to be really thoroughly prepared. Ask the dumb questions of your mentors, your co-counsel, whoever, before you stand up in front of that jury. There's no question that is too dumb, because when you stand up in front of the jury, it's too late to ask the question then. So that would be the advice I would give.
That's great advice. And La'Verne, thank you so much for all the work you're doing as the president of ABOTA this year. And thanks for all the work you do as a lawyer and helping promote the right to a jury trial. Thanks so much for being a guest. I've really enjoyed our conversation. Thank you very, very much.
I did too, Money. Thank you so much.
All right.